accountant with Bartfield's Forensic Accountants. And today we are going to be looking at confiscation and conspiracy and the conspirator. And quick look at the agenda. What is a conspiracy? Confiscation in conspiracy cases. And then I'm going to talk about the importance, or rather the unimportance, of the indictment period when we're looking at confiscation. Discuss the judgment in a case called Rooney, which is actually quite a useful summary of where we are in terms of confiscation and conspiracy. A quick mention of the treatment of jointly obtained benefit. And then I'm going to say about 2 words on available amount and finish up with the usual roundup of how Bartfield's Forensic Accountants can help you. If there's one thing that I want you to remember from this session, one thing that I want you to go away with, it's this, that in the trial of a conspiracy case, we are usually concerned about what the conspiracy as a whole has done. I was going to say achieved, perhaps that's not quite the right tone, but but about the conduct of the conspiracy as a whole. In confiscation, it's different. We are concerned with the conduct and the benefit obtained by the individual conspirator who is the subject of these confiscation proceedings. And that's the key difference. That's what we need to remember in terms of confiscation and conspiracy. But let's get into the detail. What is a conspiracy? Well, the essence of a conspiracy, of course, is an agreement. It's an agreement between 2 or more persons. And it's the agreement itself which gives rise to the offence of conspiracy. In practice, of course, that agreement is unlikely to be something that's written down and signed and can be brought forward in evidence to say these 2 people agreed on the 9th of March 2020 that they were going to rob a bank, and they actually did it a month later. You're not going to find that sort of signed and sealed agreement, are you, in this sort of a situation? So in practice, the evidence for that agreement is likely to be the conduct of the people involved, so that the existence of the agreement is inferred from the actions of the people involved pursuant to that agreement. Section 1 of the Criminal Law Act 1977 provides a statutory description of a conspiracy. And it says this: a criminal conspiracy exists where, and now I'm quoting, a person agrees with any other person or persons that a course of conduct shall be pursued. A course of conduct shall be pursued, which, if the agreement is carried out in accordance with their intentions, either will necessarily amount to or involve the commission of any offence or offences by one or more of the parties to the agreement, or would do so but for the existence of facts which render the commission of the offence or any of the offences impossible. So if I say, for example, if I agree with my next door neighbour that we are going to steal the Prime Minister's car, then that is a conspiracy. If it turns out that the Prime Minister actually doesn't have a car, and so it would be impossible to do it, well, we're still guilty of the conspiracy offence, even though the actual commission of what we intended would have been impossible. Okay, so that's a conspiracy. A charge of conspiracy will often be brought where it's alleged that crimes have been committed by an organised criminal group. But there are a couple of exceptions. A charge of conspiracy is not brought where the only conspirators are husband and wife, or civil partners. And also it's not brought where the perpetrator and the victim are the only conspirators. So, for example, if I agree with you that you're going to invest in this fantastic gold mine that I have some rights in, and actually there is no gold mine, and I'm just defrauding you, okay, we've made an agreement, and putting that agreement into effect would involve one or more offences because I'm going to defraud you of your money. But that's not going to be the subject of a conspiracy charge because the only conspirators, if you like, are the perpetrator and the victim. Most commonly, we see conspiracy charges in relation to the supply of controlled drugs. But there are a wide range of other forms of criminal conduct. For example, that can lead to conspiracy charges. For example, conspiracy to steal, conspiracy to evade duty on goods, conspiracy to defraud, and so on and so on and so on. It's very often the case following a conspiracy where there are convictions that there is more than one defendant convicted of that conspiracy. And, you know, that's fairly obvious why that could be the case. And that can lead to some muddled thinking with regard to the confiscation. Because if you're not careful, the prosecution starts to treat all of the conspirators the same. Starts to just get if you like, a section 16, copy and paste, bonk, bonk, bonk for each of the conspirators, the same benefit, the same narrative, and so on and so on. And that may not be the correct approach in confiscation. So, as I said, the key thing to remember in confiscation following a conspiracy trial is that the confiscation proceedings relate to the individual conspirator, not to the conspiracy as a whole. And so they relate to the benefit obtained, whether solely or jointly, by that individual conspirator. And of course, that individual conspirator will have his own available amount, which is personal to him. So we mustn't fall into the trap of just turning the handle and rolling out multiple Section 16 statements as if each conspirator is going to be the same in confiscation. I mentioned the indictment period, and of course, when charging, the indictment period might be widely drawn. We might have an indictment that says between the 1st of January 2020 and the 30th of September 2020, David Winch did XYZ. But actually, I might have been involved in criminal conduct in a shorter period within that time. But there's no harm done, is there, in the indictment in putting dates that we know are broad enough to cover it. However, in confiscation, we might need to know whether an individual conspirator has been engaged in criminal conduct for a period of at least 6 months. That's going to be the case particularly if we're looking at, for example, a conspiracy to steal, where it's gone on over a period of time, and perhaps conspirators have joined the conspiracy part way through or whatever. They've been convicted, and the question is going to be, do they have a criminal lifestyle? And whether they have a criminal lifestyle will depend perhaps on their individual benefit, whether it's at least £5,000, and the period of time in which they've been engaged in that criminal offence, and whether that has been at least 6 months. Now, for that purpose, we need to examine the involvement of this individual in the conspiracy. Just because you've got a conspiracy that, according to the indictment, started on the 1st of January and ended on the 30th of September, it does not follow from that that each of the conspirators, or indeed that any of the conspirators, has been engaged in criminal conduct for at least 6 months. And that could be crucial in relation to whether they have a criminal lifestyle, which of course leads on to the statutory assumptions in confiscation. Now, there's an interesting case which illustrates this. I'm not going to quote from it because the judgment deals over about eight or nine paragraphs with what's called the 6-month question. It was a case in which there were a number of conspirators, not just two, there was I think 6 or 7. And ultimately, the court held that some of them had been engaged in the conspiracy for more than 6 months and had a criminal lifestyle, and some of them had not been engaged for as long as 6 months and therefore did not have a criminal lifestyle. So the important point here is that individual conspirators can be in a different position even though they are convicted of being involved in the same conspiracy. The case is there on the screen. It's worth a look. Ultimately, in that particular case, all the confiscation orders were quashed because it was determined that none of the conspirators had actually obtained any benefit at all from the conspiracy. But that was a separate point. It does go on, as I say, in detail in considering the time over which each individual member of the conspiracy was involved, and therefore whether he did or he did not meet the requirement in section 75(2)(c) for a 6-month period. So, indictment period, unimportant. What about benefit? That's a bit more complicated. When you're considering benefit for confiscation purposes following conviction for conspiracy, we again need to look at the position of the individual defendant. So we're not looking at what the conspiracy obtained, we're looking at what our particular defendant in this particular confiscation proceedings, what he obtained. Now, of course, he may have obtained benefit jointly with the other conspirators, and that's fine. If he's obtained jointly obtained benefit, no problem with that. But he may have not obtained all the benefit that some of the other people have obtained. He may have obtained some benefit that none of the other conspirators obtained, or the position may be just somewhat unclear. It can be difficult to determine, and it's an issue that may not have been addressed fully at trial. And this is where we come to look at the case of Rooney, a case back in 2010, in which the Court of Appeal went through the various permutations, if you like, and then drew together its conclusions as to how we deal with benefit of conspirators in a conspiracy. I'm going to quote it at some length because I think it is particularly useful. What the Court of Appeal said was this, and I'm quoting, "In short, the position is, as we understand it, A, if a benefit is shown to be obtained jointly by conspirators, then all are liable for the whole of the benefit jointly obtained." And of course, that may well be the position. We may well have a situation where all of the conspirators working together as a team throughout, jointly obtaining benefit, and then each of them will have obtained the whole of the benefit which they have obtained jointly with others. If, however, it is not established that the total benefit was jointly received, but it is established that there was a certain sum by way of benefit which was divided between the conspirators, yet there is no evidence on how it was decided, how it was divided, then the court making the confiscation order is entitled to make an equal division as to benefit obtained between all conspirators. So if you've got, let's say, 5 conspirators who've obtained £100,000 of benefit, but it's not jointly obtained, it's been obtained separately by different members, but you don't know how, because of course there's, as I've said before, there's not going to be some written agreement, some sort of legal contract drawn up saying we'll split it 40, 30, 10, 10, 10, or something like that. So you don't know how it's split. Well, then the court is entitled to split it equally. So if there's 5 of them, they've obtained £100,000. The court is, in that circumstance, having found that they didn't jointly obtain the £100,000, it's entitled to say, right, we're going to say benefit £20,000 for each of the 5 of them. So that's the second possibility. There is a third possibility. See, however, if the court is satisfied on the evidence that a particular conspirator did not benefit at all, or only to a specific amount, then it should find that that is the benefit he has obtained. So where there is evidence that the court is satisfied that it does know what conspirator number 4, let's say, has obtained by way of benefit from his involvement in the conspiracy, then that's his benefit. If it can say, right, he was paid £5,000 to drive the getaway car, and that's all he obtained, then that's what he obtained. And that will be his benefit from his conduct in the conspiracy. Hopefully that is reasonably clear. And as you can see, the whole key to it is you're looking at the conspirator individually and not the conspiracy as a group activity when you're looking at the confiscation proceedings. Of course, if the defendant has a criminal lifestyle, then he is going to have perhaps additional actual benefit, perhaps additional assumed benefit of his general criminal conduct. And that is going to be personal to him. So if you're looking at a drugs conspiracy, then everybody who's involved is going to have a criminal lifestyle because the supply of drugs is a Schedule 2 offence, supply of controlled drugs. Then each of them is going to have perhaps an investigation into their transfers received by them in the period since the relevant day, which will be usually 6 years before the date of charge, and so on and so on. So they're each individually going to have assumed benefit. They may also, each individually, have actual benefit of other offences, which needs to be taken into account in confiscation proceedings against them for their general criminal conduct. Because, of course, their general criminal conduct is all their criminal conduct. So there will be personal add-ons as well as what they've obtained in benefit from the conspiracy itself. Just a word on jointly obtained benefit. Again, hopefully this is second nature to everybody. This is in your DNA. The case of Ahmad said this about jointly obtained benefit. Where a finding of joint obtaining is made, whether against a single defendant or more than one, the confiscation order should be made for the whole value of the benefit thus obtained, but should provide that it is not to be enforced to the extent that a sum has been recovered by way of satisfaction of another confiscation order made in relation to the same joint benefit. So that if myself or my brother go and steal a painting from an art gallery, a painting is worth £100,000, it's never recovered, then he and I have jointly obtained a benefit of £100,000, haven't we? If he's a wealthy man and has £100,000 in a bank account somewhere, and we're both subject to confiscation, and the prosecution managed to get that £100,000 to cover his benefit out of his bank account, then it's my lucky day, isn't it? Because I'm not going to have to pay anything. I've still got a benefit of £100,000, but because that jointly obtained benefit has already been recovered in confiscation proceedings against my brother, then I've nothing to pay. Happy days. What about available amount? This is easy, isn't it? A person's available amount is personal to him. So again, I'm sounding like a broken record here, aren't I? In confiscation, you're looking at the individual conspirator. You're looking at his personal available amount, which might be the home in which he and his wife live, or something like that. Nothing to do with the conspiracy, nothing to do possibly with crime at all, but that will be a factor in his available amount. And the fact that he is convicted of a conspiracy is of no importance in relation to his available amount. Obviously, if you've got somebody who, let's say, me and my brother rob a bank of £100,000 in cash, then if we do it jointly, we might jointly obtain £100,000. Of course, in terms of available amount, we're not each of us going to have an available amount of £100,000 stemming from that bank robbery. It just doesn't work like that, sadly. What is the law and what is the practicalities diverge. So available amount really shouldn't provide you with any difficulties in confiscation in a conspiracy any more than would ordinarily be the case, so long as you remember that it's personal and individual. Okay, so that's kind of covered conspiracy, conspirators, and confiscation. Please remember that Bartfield's Forensic Accountants remains fully staffed. We undertake legally aided work, we undertake privately funded work, we undertake criminal work, we undertake civil work for claimants and defendants. Fortunately, it has been relatively easy for us to conduct the bulk of our work remotely. Now we are coming together and meeting a bit more often in the office as things are easing up. But in any event, it's not been too great a hindrance to our work to be working remotely from home or wherever. We remain readily contactable by phone, by email, online. And the website is updated all the time. It's full of useful information, and of course, it's accessible 24/7. You can find more on this topic and other confiscation and related topics on our website in the Insights area, and this and previous webinars, recordings of those, are found in the Seminars section of the website, so that you can access. This recording will be up in a couple of days, and the recordings of our previous webinars are on there. You can access them anytime. We'll send you a free recording of this webinar. We will email it to you. And if you've any questions, any pressing questions, do please contact me. Email is best. My email address is on the screen. If I get stuff by email, I have time to think and give a considered reply rather than just trying to shoot ideas off the cuff over the phone. So thank you for your time. In a fortnight's time, we shall be back with another topic, and I have a couple of topics that I have in mind. I'm going to have to choose between them. I will see you again in a fortnight. Thank you very much for your time.